When a person is injured in an accident in Ontario, a personal injury lawsuit can provide financial compensation to cover medical costs and damages. However, the path to compensation is far from simple. The first thing to do after an accident is to seek medical help. Not only is this imperative for your well-being, but the reports compiled by your doctor can also assist with your lawsuit. If you've been involved in a motor vehicle accident, it's also very important to notify your insurance provider as soon as possible. Your lawyer will begin building your case as soon as they agree to represent you. They'll review the evidence, such as photos, videos of the accident scene, police reports, and medical records. Your lawyer will also review relevant case law to identify precedents and value damages. Once your lawyer has reviewed the evidence and built an argument, the lawsuit will be initiated by filing a statement of claim. This document describes the facts relating to your case, states why you, the plaintiff, are entitled to compensation, and lays out how much compensation is being sought. Under Ontario law, the statement of claim must be filed within a certain time limit. In most cases, the limit is 2 years, but there are exceptions. In response to your statement of claim, the defendant in the case will issue a statement of defense. This document outlines the defendant's argument and explains why they're not liable and do not owe you compensation. Under Ontario law, participants in civil claims are required to go through mediation prior to taking their dispute to court. A mediator will review both sides of the dispute and attempt to resolve the issue, often through a settlement. If mediation fails to produce an acceptable resolution to the dispute, the lawyers for both parties will agree on a discovery plan. This agreement sets out timelines for the discovery process and sets the stage for the affidavits of documents and the examinations for discovery. Both sides of the dispute submit an affidavit or documents, which is a list of documents relevant to the case to which the other party will have access. In the examination for discovery, lawyers from both sides of the dispute will sit down with the other party to ask pertinent questions. If the interviewee doesn't know the answer to the question, they can agree to provide the answer at an agreed-upon time following the examination. In some cases, discovery may take place prior to mediation. Assuming mediation is unsuccessful and following discovery, the parties will ask that the matter be placed on the trial list. Prior to heading to trial, the parties will attend a pre-trial conference, sometimes referred to as a settlement conference. During this meeting, a judge will listen to the parties' positions and attempt to find a resolution. If no resolution is found, the matter will head to trial. If all else fails, your case will head to trial. Trials are costly and risky. They prolong the claims process and put both parties at risk of losing the case. Which is why it is vital to have an experienced, trial-ready lawyer to argue your claim and secure the financial compensation that you're entitled to. At trial, both parties will present evidence and expert opinions, and may call witnesses. Once both sides have stated their case, a judgment will be delivered. Personal injury claims process can be lengthy and complex. Contact a Will Davidson lawyer for your free, no-obligation consultation and let them focus on your case while you focus on your recovery.